It says that it is.
Oh, it does say that. Okay. Well, that's strange. Are we having two broadcasts? Yes. Okay. Here we go.
Ah. Ridiculousness. We're
All
gonna want
right. We're ready. We're live, man.
Hi everyone. Today we're actually going to be starting a series on how to sue. My name is Aaron Cartwright, and
I am Lauren Cadillac.
this is Signature Block. Signature Block is brought to you today by Case Crafter and the American Association of Real Estate Attorneys. And we may have some sponsors we may have some notes from those guys later. But all right, let's get into it. Lauren,
Yes.
you have a client. They come to you with a problem. They want to sue somebody. What is the first thing that you're looking for?
For me, first thing I want to know, are there damages or are you just pissed off?
And how do you measure those?
Well, usually, well, not usually, a lot of times people are just really angry. Damages are going to be like physical or monetary issues that arose because of the other person's behavior. So like in a car accident, the damages are the repair to the vehicle and maybe any physical injury, right? So you have to have some kind of damages in order to go into a lawsuit. Now, sometimes with real estate, the damages aren't necessarily dollar bills just sitting there. The damage could be like someone's encumbering your property, right? But that is still damages.
Now, I know that in my own experience, I've had some where obviously, the real estate one that we do together, or the real estate law that we do together, plus, a lot of the construction stuff where there's an obvious sign that something wasn't done right, something requires a repair, basically something that requires an additional outlay of money beyond what you've already spent. Plus, there is, and this is kind of a side note on this one before we move to the next one here. Damages can also be something that's done to you. So in a personal injury, or not personal injury because that's very broad, but in a car accident case, obviously your car has been harmed and that requires an additional outlay of money. But in the event that, you've been hit or somebody has said something against you, there needs to be an impact called a legally cognizable harm, right? Something that has happened to you for which the law allows you to recover. Okay. A lot of the times, this is just a little heads up, there are some people, and anybody can bring a problem, but there are some times where, as you said earlier, Lauren, where you're just pissed off. There is an instance where something has happened, but the law doesn't necessarily allow for a recovery on that matter. If the mailman or some kids walk across my yard out here, I can't really recover on that one.
Unless they run over your prize winning rose bushes, right? Like, so like the damage, I get cut off in traffic every day, but there's no damages besides just being irritated, right? Like if I get cut off and hit, now we have damages.
Yep. Okay. I know that we've only got a very limited amount of our viewers' time, so let's move on to the next one. Lauren, how do you get paid? How do I get paid? How do we get paid?
Well, you and I get paid up front, so
But no, so can you explain contingency versus the hourly rates and retainers that some attorneys will charge the client?
So some attorneys will do a contingency fee, and that is they'll take a percentage of what they win at the end, and they only get paid if they win. We don't typically do that because usually we're not suing an insurance company. Those are the kind of things people do when they know there's a wallet on the other end. Usually, when you and I are suing people, we're doing something to make something right, right? We're fixing a wrong. So a little bit different. We work on an hourly basis and we require people to give us money up front. We hold that in our IOLTA and we bill, and then we move the money over to ourselves when it's earned. I'll take this brief second to say that lawsuits are very expensive. There is nothing cheap about a lawsuit.
Generally, we try to make them as economically feasible as possible,
Mhm.
but there is still some amount of consideration that has to go into that. For example, and this is just kind of the way that Lauren and I work. If you come to us with a matter that you've lost or somebody has taken or somebody has harmed you in the amount of $5,000 or less, we need to have a real long conversation about that first, because our deposit is going to be $5,000 or above, depending on the size of the matter, how many parties are involved, the complexity, so on and so forth. But our base deposit is $5,000. If you have lost less than that, and we explain to you, how much it's going to cost and all, or approximately how much it's going to cost, and you still make that decision, I'm certain that, I am more than happy to, take your money to sue somebody
Mhm.
once you've been fully apprised of the situation. But if we're not suing an insurance company, there's likely not going to be a pot of gold at the end of the rainbow unless we've already pre-identified assets. And we do get paid up front. So there is an economic decision that has to be made, which is how much money are you going to throw after this lawsuit to go get this person?
Mhm.
Okay. And yes, some people do recognize that attorneys bill that way. And so they will do stuff in very small amounts, hoping that you don't sue. All right. Lauren, can you please tell our lovely viewing audience about how to gather evidence for their lawsuit?
Okay, well, first, it's not how to gather evidence. It's evidence is a requirement. In order to sue someone, we can't just go off of what you said and you say they said, right? Those are things called hearsay, and there's a reason they're blocked in court. Um, in order to have a viable lawsuit, you've got to have some kind of physical evidence. Like back in our example of the car accident, you have a car that has damages. You have two cars usually that have damages. You have physical evidence. In a lot of our real estate cases, you have a deed or you have unfinished work. A contractor did a bad job. There's going to be physical evidence, photograph I can take physically of the bad job they did, text messages that outline agreements, that kind of thing. But there has to be evidence. It just can't be, well, it can be he said, she said, but not if Aaron and I are taking your case.
Absolutely. Oh, wait. I should probably put this on a little bit better sound. Um, But no, Lauren, you're absolutely correct about that. One of my favorite things to tell my clients as we're preparing for trial, actually way in advance of preparation for trial, as we begin to gather evidence, but also to potential new clients, is you need to imagine that your mouth is sewn shut. You cannot say a single word, and you have to assume that everybody on the other side is going to lie. Knowing that your mouth is sewn shut and you can't say a word, and everybody on the other side is going to lie or make a statement against your interest, how do you prove your case? Um, Documents, emails, text messages, recordings, pictures, anything that I can say here. I don't have to have obviously, there's some explanation, but we'll go ahead and simplify this. But if I can basically pass something to the other attorney and say, this proves this point of my client's case, that's what we are asking you guys to gather in advance. Okay, that's what any attorney is generally going to ask you to gather in advance. The more you're able to do that, the easier and faster it's going to be to get through your matter. I have had some where, unfortunately, there were some things that were missing, and we had to develop those. Developing a case adds to the bill. I
Yeah.
know it sounds terrible about adding to the bill,
Does
but
not sound terrible at all. Listen, if I go to the dentist and they are redoing a filling and then they find another cavity, that adds to the bill, man. Like that's how these things work. My plumber comes to my house, he's working on my toilet, he finds some kind of issue with my sink. Guess what? That adds to the bill. That's life. So no, it is not horrible. It's life. Hey, speaking of bills, Aaron, we have to pay ours. So let's take a quick moment to thank our sponsors.
all right, you first.
We have the American Association of Real Estate Attorneys. It's a professional organization made for attorneys that have real estate in their practice. Besides offering many discounts and perks of the benefits, members also receive leads from actual humans who need actual legal help.
Excellent. All right. And outside of my two dogs joining us, and I will murder them if they start to bark. So that is going to be very rude of them. Yes, CaseCrafter is also sponsoring Signature Block today. CaseCrafter is an automated drafting system, basically a template library on steroids. They have a way to draft, petitions and answers at the click of a button. You can draft discovery and have all of your recognized objections in the state of Texas at your fingertips, also with the click of a button. And there is an AI component that helps draft entire motions. So there is a general motion drafter, a motion for summary judgment, both traditional and no evidence, proponent and respondent, that are based on ChatGPT 3.5. I won't go into too much detail for that one, but it's casecrafter.net, and that should be launching next week.
Excellent. All right, Aaron, what else do we need to really be able to have a successful lawsuit?
All right, so we just discussed gathering evidence, and now the next one, Lauren, is how clean must your hands be?
Yes.
I know that this one is a personal preference and will depend on the attorney.
This is definitely, okay, so for me, if I'm going to file a lawsuit on your behalf, I want to go in filing that suit knowing that I'm going to be prosecuting a case and not defending necessarily, okay? So I want my client to come to the table with as clean of hands as they can. What that means, we have the clean hand doctrine in law, we have a doctrine for everything. Basically, if I enter into a contract, let's say Aaron and I enter a contract together, I want to have tried to do everything and follow the contract to a T. So that I can go to the court when I say Aaron defaults and go, look, I'm an innocent victim. I followed this contract to a T. I have clean hands. Aaron is the one who ignored the terms of the contract, so on and so forth. So we will defend people all day long. When we're defending folks, they don't necessarily have clean hands, but they're defending, they're not on the offense. If we're going on the offense, I want you to have clean hands. I want you to not have made huge and gross negligent or grossly negligent actions in this particular circumstances.
I'll add to that, while attorneys are frequently mercenary in nature, as it seems, that kind of helps both the client as well as the court system out, because we do have an obligation to the court system, aka to not waste the court system's time. But in addition to that, we do need to make sure that we have an obligation to not lie to the courts. Now, I am not lying for anybody. Okay, my license costs way too much. Sorry to say it, and I have yet to meet a case that is worth the cost of my license, in attorney's fees or otherwise. So I don't lie for anyone. We take the facts, we present the facts as best as we are able. But whenever you are presenting a case, whenever you want to sue someone, you want to make sure that you are as close to in the right as possible. Okay. So if you come to me and say, well, Lauren breached the contract, okay, that's understandable. I can work with that. However, if Lauren breached the contract after repeatedly sending notices and messages, and requests and meetings to figure out what's going on and accept an alternative delivery or an alternative service. If you've got a long history of that, you've got a problem, you can still come to the office, but we're going to figure out how to soften your landing, not necessarily win your case. Because, oh, almost forgot, juries, they go right along with that clean hands doctrine. It's one thing to convince us, then we have to convince the other side, then we have to convince the judge in order to make it through a motion to dismiss or a summary judgment. And then at the end of that, we still have to, convince a jury. And if this story just doesn't add up, if it doesn't add up, then we'll just advise, or I am likely to advise you of that and provide you with options, just in case your hands aren't as squeaky clean as, you'd like them to be. All right. I believe that's all the topics that I've got and all the time I want to take up. Lauren, do we have anything else?
No, I mean, I feel like that really, if you're contemplating, do I have a lawsuit? These are the first things you need to ask yourself. So I think we've gone over it, and if you asked all these questions, you had clean hands, there are damages, give us a call. We're more than happy to help you.
Excellent, excellent. All right, my name is Aaron Cartwright. That is Lauren Cadillac. Together, we are Tierra Law. And you can reach Lauren. I'm not going to say Lauren's side of the office, but there are two phone numbers that you can reach us at. One is 972-845-1200. The other one is 214-799-0776. Wherever you found this video, stay tuned. We are going to continue doing this series based on various parts of lawsuits and how to add to that, as well as some other general and specific legal knowledge.
Excellent. All right, everyone. Thanks for joining us.